Ready? All right, let's roll, nerds.
All right, page 2, Arsenal. That's one of your, it's ready. Arsenal.
Antoine Arsenault, come on up.
Yes, sir.
Mr. Arsenault, you are charged with interference with the emergency request for assistance. You are facing up to a year in jail and or a $4,000 fine. It seems that probable cause has already been found in this case.
Yes, sir, Judge. I don't know why we're here, but,
Because he bonded out.
Oh, yes.
I guess he's been AWOL, right?
no, sir, he's been in custody, Judge. He was, he had a felony, assault of a family member that was dismissed, last week,
Okay,
and that's why he got out.
all right. So are there any kind of bond conditions that you guys would like state?
So for this one, just standard condition would be fine with this type of case. And there's no contact for this,
Who's the complaining witness in
His mother, Judge.
his mother, judge.
okay. Is that the complaining witness that was in the felony as well?
That's correct, Your Honor.
Okay, so I'm ordering you not to have contact with this person. Do you understand?
Judge, if I may, I provided the state with some information relative to that. The complaining witness in this case is not willing to go forward. She provided a letter to me, which I have already given to the state. She's requesting that the case be dismissed.
The state would not be opposed to no threatening or harassing contact at this time. And just give us another date to reset to look at the 911 phone calls to make sure that.
Okay, so the case is 180 days old. It's time. So I'll give you a
Okay.
week.
Yes, Judge.
So I'm ordering you not to have any threatening or harassing contact with the complaining witness in this case and not to be in possession of weapons. If I find that you violate these conditions, I'm going to revoke your bond, put you in jail. Do you understand? I'm not asking for much. Now, your case is old. It's time to figure out what we're going to do. So I'm going to give the state a week to get everything done, wrapped up. They're going to put an offer on the case. The next time we come back, you must either accept the offer or I'm going to set your case for trial. Do you understand?
Yes, sir.
Okay, so do you mind filing those conditions, please?
Yes, judge.
All right, we're gonna have you sign the conditions. After that, we'll see you in a week. We'll go from
Thank
there.
you, Your Honor.
Okay, thank you, Mr. D.
Yes, sir.
Right this way. Judge, did you say that was state's bond conditions?
Correct.
Okay. Next, Judge, is bottom of page 3. Venegas. Come on up.
Hi, good morning. Thank you for coming back. Did you run his license?
Yes, judge. I'll run it right now.
Please. Mr. Venegas, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. I have previously found probable cause on this case. I'm ordering you now as a condition of your bond not to participate in like-kind activity. If I find that you're racing, reckless driving, acting a fool on the highway, number one, I'm going to revoke your bond, put you in jail. The second thing is I'm going to take away your privilege to drive. Do you understand?
Yes, Your Honor.
Do you see if he has a license?
Still running it, Your Honor. For some reason, it's slow.
Mr. Venegas, you are not allowed to drive unless you have a valid Texas driver license and liability insurance. That is also a part of your bond conditions. If I catch you driving and you don't have a license or you don't have insurance, it's not going to go well for you here. Do you understand?
Your Honor.
Okay, you have a lawyer. It is your responsibility to stay in touch with him and he'll tell you when you have to come back. If he tells me he can't get a hold of you, then I'm going to issue for a warrant for your arrest. You pick up a new case, act a fool in the free world, I'm going to take it away.
I'm able to run it right now, Your Honor. It's not letting me on our system.
So can you file the same conditions on the racing that we
Same
did?
racing conditions. Yes, judge.
All right, so I'm going to have you sign a reset. After that, we'll have you take a seat in the jury box while we'll get your bond conditions. You have to sign it, and after that, you'll be free to go.
Thank you, Judge Mack.
Please. Yes, sir.
Right this way.
Sean, do you have an arraignment?
I have new conditions.
All right, how is March?
You ready? Do you mind bringing them up?
This is order.
You are not allowed to drive. Do you understand? If I find that you pick up a new case or another third case, I'm going to go nuts on all of the bonds. I'm also going to test you 45 to 50 days from today. You're not to use marijuana at all. Do you understand? If I find that next time I test you and you test positive, it's just not going to go well for you. You understand? We've given you a lawyer. There's just no more excuse. If you get your license and insurance, Mr. Jackson, I will happily take this restriction off. All I'm asking you to do is follow the law. I'm not asking you to split the atom here. Really.
And Judge, we're working on it. We have a out-of-state fine or suspension, but we cannot figure out what state it comes from at the moment. So we are
Call DPS, you know.
because they're even
You
when they
can
run.
call DPS. Have I given you the phone number?
I don't think so, but
Hold on.
I think it's in Jacksonville.
Do you mind giving this to me? This is the number to the driver's license division for DPS. When you call, you have to call at 7 o'clock in the morning. Do not call at 8. Do not call at 9, 102, because you'll never get through. Right when the phone line's open, call them. All you have to do is ask them, what do I need to do to be able to get my license? And then they'll tell you. All right, I'm gonna have you come up here, promise to us that you're not gonna drive, then I'll get you to Victoria Center Reset. You'll get with Felicia for your bond conditions, and after that, you're ready to go. All right, good luck, guys. You got it.
All right, so the next is
Ford Jackson.
Page 19, Johnson, Sheriff.
Are you Sherry Johnson? Ms. Johnson, you're charged with making a false report to a police officer. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On January 19th, 2025, at approximately 1:56 p.m., the officer was dispatched to a child custody dispute at a residence in Harris County, Texas. The officer made contact with the defendant's husband, who requested a report be completed because the defendant did not meet him at a scheduled time and location. The officer made contact with the defendant at 4:45 p.m. via the phone, and the defendant was advised about the husband's request for report. The defendant became upset and stated she was going to call the defendant's probation officer and say what she needed to say to get his probation revoked and serve 2 to 10 years in prison. The defendant stated she had video footage of the husband assaulting her last month on the phone, and she was going to call and have a deputy come to the residence to pursue charges because he completed the report. At approximately 5:37 p.m., the defendant made a family assault call, and the call slip stated, "See reportee," in reference to husband cussing and pushed reportee. The officer, who had previously contacted the defendant, arrived at the family assault call at approximately 6:02 p.m. and made contact with the defendant. The defendant stated the husband pushed her on 2 separate occasions in January 2025, and the defendant then stated the husband did not punch or push her, he merely brushed against her and admitted it was not intentional. The officer asked to see the video the defendant stated she had. The defendant denied making that statement, and the defendant then admitted to making the statement and stated she did not have a video, but the daughter was present. The defendant stated she did not feel pain, did not have visible injuries, and wanted to pursue charges. The defendant then attempted to change statements again, stating she never made a call for service. The officer read the call slip, and the defendant stated dispatch did not hear her correctly, and that was not what she meant to say. The defendant further denied making a statement regarding the husband's probation. The officer replayed a body-worn camera video of the defendant's statement while on the phone, and the defendant admitted she was not telling the truth.
All right, ma'am, I'm gonna find if there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand? That is the gentleman in this case. If I find that you have contact with this person, I'm going to revoke your bond. Look, I can provide you a lawyer today. You can explain your side to the lawyer, but I've got a bunch of DAs here. Anything you say, they're gonna try to use it against you to prove guilt. Just don't. I will give you a lawyer. Just explain your side to the lawyer, and then they can go talk to the DAs on your behalf. But I don't want you to say something where you put your proverbial foot in your mouth, you know? Don't. Just, so what I'm gonna do is I'm gonna have you sign a receipt of Victoria. I will have you then take a seat in the jury box. I'm gonna find you a lawyer, and then you can explain your side to the lawyer, okay? Let me see one thing real quick. I need you to fill an application for me, though. Do you mind? She's gonna give you an application. I need you to fill it out, and then I'll have you talk to someone here momentarily. No. Please. Can you file those conditions, please?
Yes,
No
Judge.
contact and no one.
Yes, Judge.
Go ahead and sign and release that, please. All right, Judge, next is page 29. Rezon, Topaz. Come on up. Thank you.
Ms. Prejean, you are charged with aggregate theft. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. The officer met with the complainant, the Walmart asset protection employee, and the complainant stated that he reviewed store surveillance. And on September 12th, 2023, the complainant observed the defendant open the register multiple times, take cash and place the cash into pocket, a total of $790.41. On September 13th, 2023, the officer observed the defendant conduct a fraudulent return for a total of $60.02. And on September 18th, 2023, the complainant observed another fraudulent return by the defendant for a total of $101.77. On September 20th, 2023, the complainant observed the defendant process a fraudulent return, take money from the register, and conduct a fraudulent return to obtain a gift card following the transaction for a total of $120.64. The complainant stated the defendant did not have permission to take money and desired prosecution. The officer made contact with the defendant, who admitted to stealing from the business 4 times, with each time being $200.
All right, ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to go to any Walmart for any reason. Do you understand? If I find that you go to Walmart, then I'm going to revoke your bond. I'm going to put you in jail. Did you need a lawyer, ma'am? Okay, I'll appoint you one today. I'm going to have you sign a receipt, Victoria, then we'll have you take a seat in the jury box while we find your lawyer, ma'am. Mind filing those, please?
Yes, Judge.
All right, Judge, next is page 30. Bryce, come on up. Carolyn Price. Oh. All right, go ahead and fill that out.
Ms. Carolyn Price, ma'am, you were charged with assault. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On January 20th, 2025, the officer arrived at the complainant's apartment due to a disturbance call, and the complainant asked the defendant to leave her apartment after a verbal argument. The child was present, and the defendant then pushed the complainant, leading to further argument. The defendant, instead of the complainant, landed at least one with her right hand, which were also holding a pair of keys. The keys scratched the complainant's face, leaving red marks. The complainant then held the defendant on the floor to stop her from punching her until she calmed down, at which time the defendant proceeded to spit in the complainant's face. The complainant then let the defendant up and told her to leave. The complainant stated her pain level was about a 3 out of 10, and the officer observed the complainant to have 2 red scratches on her cheek.
This is the complaining witness to Mr. Price, please.
Your Honor, the complaining witness is her mother, the grandchild, mother of her grandson.
Ms. Price, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you not to have contact with this person. I'm also ordering you not to be in possession of weapons as well. Did you need a lawyer today? Ma'am? Okay, I will appoint you a lawyer. For now, I'll have you sign a receipt. Victoria will have you take your seat in the jury box. Do not leave until you sign our bond conditions, then I'll have you speak to the lawyer. Okay, please. So you can file the standard conditions.
Okay, yes, Judge.
Yes. Thank you.
Judge, did you
Yeah.
say financial application?
Mhm.
Yes, please.
All right, Judge, next is page 32. Saldana? Central?
Good morning, ma'am.
I do have a lawyer, but he's not here yet.
Who's your lawyer?
Denuna, Chris Denuna.
Kristen Nuna?
Mhm.
Have you heard from Chris? So, Miss, yeah, I see that he has signed on to your case. If you would like, just go ahead, take a seat, and as soon as he gets here, we can do it. Okay, please.
Fill it out in the jury box.
Good morning, Mr. Butler. We'll wait till Chris gets here. Yeah, just take, don't leave, man.
All right, Judge, next is page 36. Tovar Martinez.
You were Miss Tovar Martinez. Do you speak English?
Yes.
Okay, ma'am, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 20th, 2025, the officer, a certified DRE, was dispatched to the scene of a wreck at a parking lot in Harris County, Texas. The defendant had been refused entry to a bar at the location due to appearing visibly drunk by the staff. A witness stated the defendant was not walking straight and had a hard time standing. The officer observed the defendant trying to back up from the scene of the wreck when he made a stop. The defendant had watery eyes, a strong odor of alcoholic beverage, and furthermore, the defendant was not making any sense when describing what had transpired to the officers. The defendant was transported to Pasadena jail, where Miranda was read and SFSTs were performed. HGN 6 out of 6. Walk and turn. The defendant took 15 steps instead of 9 and missed every heel to toe. In the one leg stand, the defendant used arms and swayed. The DIC was read and the defendant consented to breath. The results were 0.212 and 0.217.
And Ms. Tovar Martinez, I'm going to find that there's probable cause to go forward with your case. Did you see if she has a valid license, please?
I'll run it right now.
I am now placing a restriction on your license, ma'am. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If I find that you drive a vehicle that doesn't have one, I'm going to revoke your bond, put you in jail. No more PR bonds. I am also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're using anything illegal, likewise, you will go to jail. No more PR bonds for you, ma'am.
We have no license on file.
You do not have a license to no driving. Do you understand? You will be signing an affidavit with me today, promising you're not going to drive, and I don't care what is going on in your life. Do not drive. Since I'm ordering you not to drive, you will get a handheld interlock device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol, man. I'm sending notice to DPS in Austin that every single officer in the state will know that if you get pulled over, you're supposed to have an interlock in your car. So if you're driving a vehicle that doesn't have one, they're going to put you in jail. Do you understand? Would you like a lawyer today, ma'am? Okay, so for now, what I'm gonna do is I'm gonna have you go to Victoria, sign a reset. You will get with Felicia for bond conditions, and then I'll have you take a seat in the jury box while we try to find you a lawyer, ma'am. Okay. See,
Right this way.
Come right here, please.
no, I have one already.
Yes.
We're good. Okay.
Judge, do you want to start with the THA?
Sure.
Raise your hand. You can jump in the booth. This one is going front, and you want to operate in it, we'll be able to have a valid detective driver's license.
Right,
Or-
page 8, Marsdell, come on up.
Raise that over there.
Good morning, Mr. Cornett. You have a lawyer today. Did you want to apply for a court-appointed lawyer? Okay. Do you mind giving him an application? All right. I'm going to give you an application for an appointed lawyer. Fill it out for me. And then we'll have you talk to someone here momentarily, sir. Please.
All right, Judge, next is page 8. Daniels, come on up.
Morning, Mr. Daniels.
All right.
Do you have a lawyer today?
Sorry.
You want to apply for a court-appointed lawyer?
I just started working. I'm gonna give them, I know I was just a second, but I might
All right, but not a seat in the jury.
have a lawyer next quarter. Just have.
I'm willing to give you a free one.
Okay.
Okay, it's up to you. If you have any problems, come back.
I just started working, so I'm saying,
Good job, man. Great. What are you doing?
delivery, so.
Jackson?
Third parties,
Get a trade, dude. Get a trade. Go like welding or something like this.
I got my forklift, it's hard finding jobs, it's hard, so I knew somebody that got me in with the delivery, so.
Good.
Yeah.
You know, the better you do, the higher you're gonna go. Anything in life, man. Put your heart into it. Your sky's the limit. Right. Okay. THA. All right, we got you, man.
Thank you.
Good luck.
Okay, just sign it, just. All right, Judge, next is page 22, Lockridge, come on up.
Good morning, Mr. Lockridge. Do you have a lawyer today? I'm applying for a court-appointed lawyer.
Yes, sir.
Okay. Do you mind giving me an application? All right. I'm gonna give you an application. Just fill it out for me, man. Look.
Next, Judge, is page 36, Tovar, Luciano.
Morning, Mr. Dover. Good morning. Do you have a lawyer today?
Yeah.
Who's your lawyer?
Diana E. Sims.
Okay. You know if she's gonna be here today? Perfect. Just take a seat. We'll wait for her to get here.
Right this way.
Raise your hand.
Good morning, Judge. Check the chat.
But are you ready to say?
Oh, really?
Yes, Judge, they just called.
Do me a favor, will you? On the sound bar, can you hit the power, please? I can't hear you.
We're still pending the discovery.
Yes,
something.
Judge, they just called. Can you hear me?
Did you get a date by chance or no?
No, I didn't ask for a date. And the office couldn't give me any information other than he was involved in an accident.
Is he okay? I hope he's okay.
She didn't say.
Okay.
I just told her that I would let the court know and have the
Okay.
client call the office when she leaves court
Got it.
today.
I guess we'll just do like a 30-day regular setting for whatever day, and then they can always come in and off docket.
Right.
Okay.
Right. Thank you, Judge.
Thank you, Ramona. Miss Aldana, come up. So ma'am, it looks like your lawyer was involved in an accident this morning, so he's not going to be here. So what we'll do is we're gonna do probable cause. After that, we'll just give you a normal reset. They called us to advise you to call the office and then you guys can get together with them, okay? So ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes.
Okay.
On January 19th, 2025, the officer was dispatched to a target in regard to a theft. The officer made contact with the complainant, a loss prevention employee, who stated she observed the defendant walking inside the store, grab a shopping cart, select numerous items, place the items inside the basket, and conceal cosmetic items, food, and office items inside her purse. The defendant headed to the register where she only paid for the items in her basket before exiting the store and passing all points of sale. The total was $111.28.
All right, Ms. Saldana, I'm gonna find that there's probable cause to go forward with your case. Where is this from again?
Target.
Target. I'm ordering you as a condition of your bond. Target, do you understand?
Yes, sir.
If you violate this condition or if you pick up a new case, a warrant for your arrest will be issued. No more PR bonds, ma'am. So can you file that, please?
Yes, Judge.
I'm gonna have you sign a reset. We'll have you take a seat in the jury box while I get your bond conditions. We'll have you sign it, and after that, you'll be free to go, okay? So Danuno was in an accident this morning, I guess, so he's not gonna be here. So we'll just do a regular reset, just do, I guess, 30, 45 days. And then she needs state's conditions.
Okay, plus, so we had a couple of, so I can sign this. Page 1, Acosta, Jose. He was THA judge.
Okay,
All right, go ahead and have Steve in the jury.
what, can you call up all three? Let's just do them right.
In the jury box.
Mr. Acosta, do you have a lawyer today? Did you want to apply for a court-appointed lawyer?
Come on up.
I think I'm gonna find one myself.
Okay, I'll have you go to Victoria, we'll have you sign a reset, and then we'll get you on your way then.
You said-
THA on this gentleman. Okay, Mr. Acosta, please.
Acosta?
What is your last name, sir?
Pido, señor.
That is, it's 28.
Thanks. Mr. Perez, do you have a lawyer?
¿Tiene abogado?
Mm, mm,
No, I haven't.
Did you want to apply for a court-appointed lawyer?
No, no tengo, yo, dentro de lo que sucedió.
He says, I know what happened.
So,
I don't want you to say anything.
Que usted diga.
You have a lot of valuable rights. And when you start talking, you will start putting your foot in your mouth. You need a lawyer to represent you in this case because it has far-reaching consequences. Do you understand?
¿Entiende?
You need
Usted
a
necesita
lawyer.
un abogado.
You can either hire one or you can apply for a court-appointed lawyer.
Un abogado de
So the
oficio.
decision is yours. What would you like to do?
¿Qué desea hacer?
aplicar con,
Apply for an attorney.
Okay,
Muy bien.
I will, deputy will give you an application. I will take a look at it,
Y lo voy a revisar.
please.
Abajito de cada cosa está en español. Llénalo enfrente y atrás.
Judge, was that a financial affidavit for Perez?
Yes, ma'am.
Okay.
Did you get this? Who is this? What is your last name, sir?
Su apellido.
Julio Hernández.
What page was the last one?
Last one, Judge, is page 37. Ola Fernandez.
Got it. Mr. Uloa Hernandez, do you have a lawyer today?
No, un abogado. No.
Did you want to apply for a court-appointed lawyer, sir?
Señor? Yes.
Okay, we'll give you an application. I need to know everything about you, and then we'll see whether you qualify for a lawyer. Please.
All right, Fremont?
Thank you so much, Blossom.
Yes,
You need the cause numbers?
I'll get them for Victoria all of them.
Okay.
Good morning, Your Honor. Morning. Wanted to approach on behalf of Chaston Blackburn regarding probable cause. I have issues with probable cause in this case, Your Honor.
Okay, let's do it. Alex, you ready?
So officers were conducting an unrelated fatal accident investigation when they observed the defendant's vehicle traveling at a high rate of speed towards the blocked portion of the roadway. The officers saw the defendant disregard a barricade and were able to successfully get the defendant to stop by shouting verbal commands and utilizing their flashlights. Upon contact, the officers observed a moderate odor of alcoholic beverage, glassy eyes, watery bloodshot eyes, and slurred speech. The defendant admitted to having 3 drinks at a nearby bar and was temporarily detained. Standard filters bright were conducted, HGN 4 out of 6, walk and print 4 out of 8, one leg stand 2 out of 4. DICs were read and the defendant consented to breath. The results were .086 and .084.
Your Honor, when you turn on the video and it's between,
But remember, this is probable cause. I don't get access to all that stuff.
I understand that, Your Honor, but when the officer basically decided that he's going to arrest her, basically he puts her in the vehicle and before any investigation is done, he says, I'm charging her. This is prior to basically any field sobriety tests being done. She didn't have any slurred speech, Your Honor. No bloodshot red eyes at all. He said all the buzzwords to trigger probable cause. I'm asking the court to watch the video for 5 minutes, Your Honor.
No. That's in for a suppression hearing. This is a mere probable cause, right? So because I have to give them the ability to respond to your arguments. We can't do that in a probable cause, like, you know what I mean? So if you're saying it is as it is, see if they'll do a dispositive motion to suppress, where if you win, they'll dismiss, but if you lose, you got to plead, right? Otherwise, we can set it. But, when you start getting into the video, when you start getting into the minutia of, well, she really didn't have this, she really didn't have that, I have to give them the ability to respond to that. I can't just rule on it, whether, there was an actual traffic infraction, that's like probable cause or not, right? But when you start getting into the actual details, everything, I mean, that's for, either a suppression or for trial.
That's very
So ask them if they're good for, dispositive. That's something that you want to do. Let me see. It's only 60 days old, so you've got some time, I'm happy to do however, go forward with however you want to go forward, but for probable cause purposes, you're getting into argument, right? And I can't give them, I have to give them the ability to respond, Okay, sorry. Mr. Nooley, hey.
How are you, sir?
No, man.
Fine. I'm trying to revisit a PC for Mr. Resendez Artimio.
Okay.
You want the cost number, Judge?
It's on docket today, right?
Yes, Judge.
I see it here. Okay. Okay.
Yes, Judge. So for Mr. Resendez, on October 8th, 2023, officers were dispatched to a crash on West Sam Houston Parkway, and upon arrival, the officers observed the defendant's truck stopped in a moving lane of traffic with a flat tire and fender damage. The defendant was standing outside the car, but admitted to driving and drinking that evening. The officer observed the defendant to have bloodshot eyes, glossy eyes, and a moderate odor of an alcoholic beverage. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 2 out of 8, one leg stand 0 out of 4. The defendant consented to giving a breath sample, and the results were .074 and .073.
And Your Honor, regarding that dispatch to a crash, we did request an accident report and then found out that this was just about the defendant's tire having been popped. There wasn't an accident report that we did in fact find. It was a flat tire front fender damage, however.
That's where we are, Judge. Defendant had told me that as he was driving on the parkway, he had a pop on his tire in the middle of the road. So at that time, he has to stop and was trying to wait for the subsequent traffic to clear. And that is all. There was no accident, just like,
I know, but that's not that's not definitive, right? So what happens is a cop comes to investigate, right? And I guess that's when he sees. So, there are several theories in the law, like community caretaking, right? Where an officer is just going to make sure that someone is okay, and when they arrive, they start seeing indicia of intoxication, and then they can, I guess, you know.
yes, yes. And the blood is out now, and it's not up to the legal limit of 0.08 two times. So even if we find the average, we're still below par.
Right.
And that's where we are now. So when I spoke to her, she said, well, unless if the judge will not find it peaceable, but she's so.
Yeah, I mean, I think, remember, this is just to go forward. Whether they're guilty beyond a reasonable doubt, that's something completely different. But, you know, taken as a totality by himself, there's, like, it's not an accident, but the cop can, you know, come up and just look to see, hey, is everything okay? And then that's when he sees.
If you look at the totality of the circumstance, Judge, and anybody using the road, it could be a judge, it could be me, and you have a pop of your tire in the middle of the road, it's expected that you stop. And you have to wait to get clearance to park your car properly. So if somebody may have thought it was an accident, like they had assumed before, in this case, the state said within themselves, it wasn't an accident. And
There's nothing wrong with an officer just coming and riding up to a scene to assist someone. I don't think that there's anything wrong with that. And then when he goes to assist the person, he realizes, hey, there might be something else that's afoot here. And then that's when he begins the investigation, right? It's enough for PC, but it may not be enough for reasonable doubt, you know? There's a 0.07. I don't know what happens with the field sobriety test. Have him eval it for trial, you know? And perhaps and they'll see, let's set it.
Yes, Judge.
Let me see how old this is, Resendez. Oh my God, it's 477 days old. Oof.
because they're waiting for the blood.
It took 2 years though? Yeah, he was gone for a year. So let's do this. Let's set up for a week. Will you eval it for trial to see, is this something that you can actually make? I mean, you know?
Yes, Judge, we'll eval it.
So let's set it for 1 week. Let me have them eval it. Can they make the case? You know, it's not about just convicting every single person. It's about doing justice, right? So let's see. There is enough just for probable cause, but let's see what they say about it. Okay?
Thank you, Judge.
Okay, thanks, Mr. Moore. I mean, whoa, come on up. Wow.
Love the jacket.
Wow.
Love the
In the flesh. It's been so long. How are you?
Good. I had an opportunity to come here and I took
Great.
it. So, yeah.
Fantastic.
Judge, I have a client on a felony.
Okay.
It's a PACA first setting in the 339. We were up there getting everything squared away. I wanted to let the court know that's why he was late here. But I also wanted to see if the court would be amenable to appointing my office on the misdemeanor. If that's
Absolutely.
appropriate.
Absolutely. But you said Zavata?
Hernandez, Francisco Hernandez.
Is today for us, is it
Today should be an arraignment for y'all.
yeah, let me see, Hernandez. It's Francisco?
Francisco. Mhm.
Francisco Hernandez, come up.
And Judge, he's in high school, 17-year-old. That's why I wanted to make sure I came with him.
Absolutely. Happy to do it.
Thank you.
Good morning, Mr. Hernandez. Mr. Hernandez, you're charged with evading arrest or detention. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 19, 2025, at approximately 11:17 p.m., the officer was dispatched to a discharge of a firearm call on Tilbury Woods Lane. Multiple calls stated there were multiple gunshots in the area, and while servicing the area, the officers were flagged down by a citizen who stated she heard multiple gunshots and a green sedan sped off. Multiple citizens provided video footage, and the officer saw a vehicle that matched the description parked illegally in front of a residence on Moss Springs Court Road, and multiple males exited the vehicle. The officer then initiated a traffic stop, and the driver and passengers began evading on foot. Officer ran after all three males for 100 yards, and all were detained by the officer. The defendant and others admitted they saw emergency equipment and decided to evade on foot. Surveillance video showed the defendant throwing an AR pistol with no serial number in front of the residence, and surveillance video matched the defendant's clothing.
Saying our defendant here was seen throwing an AR?
Allow me to read the DMs to confirm that it is.
Sure. They filed a tampering. Am I right in assuming that that's the serial number?
Yes, Judge, it is this defendant throwing the AR, and the firearm had no serial number. Yes.
How can you impute the tampering? Because it's a specific intent crime, right? Unless you have an admission or something like that, something that happened. But you know what? That's not even my forte. It's like, we're doing the evading right here, so.
Fighting upstairs, gonna
I
fight
gotcha.
down here too. So you can already expect my issues with this case already.
No, you're 17, you're now starting your life. This is not a good way to start, you know? You only have two ways that you can go. You can go up or you can go down. Life doesn't get easier the older you get. It only gets more difficult. You get bigger, fatter, you lose hair. It doesn't get easier, and it starts with school. Stay in school. Don't hang with dogs. You're gonna get fleas. Do you understand? Mr. Hernandez, you are not to smoke weed, you're not to use alcohol, and I'm making that a condition of your bond. I don't want you to have any possession of any weapons as well. Do you understand? If I find that you're in possession of a weapon, I'm going to revoke your bond, I'm going to put you in jail, you're going to finish school with me. You understand? Did they impose any other kind of restrictions up there as far as like curfew or anything like that?
They did not. At first, he had an ankle monitor with the curfew. I asked the court, they agreed to take it off. So his mother and him are gonna go after this court proceeding to get that removed.
Is mom here?
Mom is here outside with his younger sister.
Okay. Make good decisions, man. Once you start racking up convictions, I'm telling you, it's over. It's not gonna get easier. You understand? We've given you a lawyer. It is your responsibility to stay in touch with her. She's great. She will help you out. If you're not listening to her, you take off, I can't find you, you pick up a new case, I'm gonna put you in jail. No more PR bonds for you. Do you understand? One more thing. I will test you in about 45 to 50 days. And if I find that you're smoking weed, it's not gonna go well for you. Do you understand? You will get tested. Be ready. So I don't care what you're doing. If you stop using, if you stop doing anything that you shouldn't be doing now, then you should be fined in 45 to 50 days. But if you continue to use, or if you smoke, it's not gonna go well. You understand? Okay.
Thank you.
Thank you so much for coming. We got you. And then anything you need, whatever you need, just come back and we're happy to help.
Thank you, Judge. And just one thing real quick with the state.
Mhm.
I know there's other people that were in this vehicle allegedly. Do you have any names for them? Can you,
I can see.
if I circle back around from you?
Oh, co-defendants? That's a good, because you know what?
Well, that's part of my issue with both of these cases.
And Your Honor, it does not appear there's any connected cases.
So I have,
So
yeah, that's my issue with the tampering. That's my issue with this case.
They got them all, right?
That's what they say.
Maybe just because of the surveillance shows allegedly one being thrown and that's why they only went after. Perhaps, I don't know. But
I won't fight everybody too crazy today, but probably the next day. Yeah.
I'm with you. You know, whatever you need, just
Thank you, guys.
make good decisions. That's all we're asking you to do. All right? Okay,
you very
guys,
much.
thanks. You got it. So, Mr. Hernandez, do not leave because we need you to meet with pretrial, okay?
yeah, we have the OR, so
Okay, you have the order?
it should be, are you connected to the case? Are you attached?
Oh, I see it now.
Okay, perfect.
Okay, thank you so much.
Thank you. Hi, Amy, come on up.
Hello.
Hi.
This
Hi.
is Nicole. She's
Hi, Nicole.
new addition to Gemini. She's gonna be helping
Wait,
us.
what'd you say?
She's our new addition to Gemini.
Oh, nice. Great.
She's going to
Nice
be
to meet you, Judge.
helping us out with pages in the future.
Fantastic. Great. Do you have full?
I do.
Wonderful. Great. Is they leaving?
No,
No?
he's still here.
No?
He's still gonna be here. Yeah.
Great. Okay,
I'm
thanks.
days understudy, Judge.
You're in good hands, really. With both.
Sign.
Hey, how are you?
Good, how are you, sir?
Happy Monday.
I'm sorry, I couldn't hear you.
Happy Monday.
Oh, happy Monday.
I have one of our trial cases for tomorrow.
I believe I have one set, but I think he pled his felony.
It's Mendoza.
Yeah, I think he pled his felony, and if not, I will announce not ready, mostly because I got texted some videos last night. Well, I got emailed some videos last night.
Let me pull them up real quick. Hold on.
I feel like he was dismissal if he pled the felony, and then I think they rushed the felony.
Judge, do you have the case number?
I do.
Okay.
2502-101
And 02.
and 02. They reset it.
I don't see it.
219.
No. My
Yes.
problem is I have they all overlap, and I swear I have two reckless drivings, each of them with a gun, and one of them called my office to say he pled. I guess it might have been the other one.
Our gun case pled, but the reckless driving is still open.
Okay.
And then it looks like the felony evading in the vehicle got reset to 219.
All right, let me hold off on that till tomorrow, Judge. Because I came in here thinking that they had pled upstairs. And I obviously got the guy confused who pled upstairs. So let me make some phone calls. Because a client called me to say that he had pled. And I thought it was this one.
What are they doing upstairs? Is there any news?
We're in touch with defense upstairs and the defendant is gonna take the deferred and felony and then dismiss our cases, adding the condition about the firearm, I believe.
Yeah,
You're doing a TRAS, is that why they did the reset? Are they doing a TRAS upstairs? Is that why they did the reset? Because a lot of times prior to a plea, they'll do TRAS.
You reset from the last setting without actually agreeing to plea. Kelsey then sent out the email, hey, will you do it? They agreed to plea. I thought my client called me to tell me that he had done the plea. I think he has now agreed.
Did they do the plea? And they just set it to do a TRAS?
They hadn't officially done it yet, sir, but I'm talking to the felony defense counsel, and we were hoping you could just come do it tomorrow when this one's set for trial, but we wouldn't actually be going on it because that was the agreement.
Bless you, wherever you are.
Is he in custody?
No, he's not on.
I'm looking at I'm just looking at.
I will say, I got the cell phone video that was emailed to me yesterday, and it's not particularly reckless. Yeah, the donuts, there's a good distance between him and all the other cars. Shush.
On the reset, they didn't mark anything, and then under settings, it's just a non-trial setting.
So they reset it, and then after they reset it, Kelsey, and I'll give all the credit to Kelsey, sent all the emails and got everybody to agree to take the plea. So all the paperwork was before the defendant had agreed to take the plea.
You said you want to set it for tomorrow?
No. I thought he had already taken it, and I think we're set tomorrow.
Right.
So I can have the
Want to go
client come
ahead
in
and
and
set it?
Well, I can walk him up to felony court, except for the fact that I'm not his felony lawyer, so I can't take the plea.
I'm not asking you to do that.
No, what I was saying is I
Set
could
it
normally do
after
that.
the felony.
Oh, yes, please. But I would say leave it for tomorrow, because I don't want to communicate with the client. Like, if he's not set tomorrow, I might not be able to get a hold of him, and he might come in anyway. So if we leave it
We don't
tomorrow,
know.
he comes in, I say hello, and then I set it for the day after the felony.
So what if he doesn't show?
Tomorrow? Oh, tough tin of beans.
So I revoke it?
I would hope not, but that's a conversation I'll reserve for tomorrow.
I mean, once, okay.
Yeah. You're thinking two steps ahead, but like kind of in a lateral direction as well.
Have to.
I know, but right now we have a resolution, it's plotted out, we're gonna get this resolved.
With you.
I'm choosing to think positive. Also, I'm trying to suck up to this one because I need a time served offer on a different case.
Okay.
All right, thank you, judges.
After finding that, saying,
Judge come at you how you plead guilty, not guilty, but he's not gonna find you guilty. He's gonna find you guilty, he's gonna place you on 15-month probation. Yes, sir, and no, sir. How you plead guilty, not guilty.
I'll just make it. Yeah.
Good morning, Mr. Harris. Mr. Harris, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you a 15-month deferred. This is a type of probation that if you successfully complete it, you do not end up with a conviction on your record. What you must understand, though, is there is an affirmative finding of family violence in this case, meaning that you ever pick up another one of these cases, you will be facing a third-degree felony, minimum of 2 years, maximum of 10 years in prison. Do you understand? For you to complete this successfully, you must do a Batters Intervention Prevention Program, a BIP class. This is tough because this class is you must do it once a week for 18 weeks. And if you fail to go 1 week, they're going to kick you out. You get kicked out. We issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out. You're facing up to a year in jail. Do you understand? It's no joke. No alcohol, no drugs. You must do also what's called a TRAS, an evaluation, to see what other conditions you may need. If they assess other conditions, you have to fulfill them as well. Do you understand? No weapons, no harassing, threatening, abusive contact with Brittany Senegal and Chanel Clayton. Mr. Harris, I will make you a deal. If you get this done quickly, I will take you off in half the time. If you're nice to everybody, get your classes done quick, sign up as soon as you start getting this thing, I'll take you off in half the time. You can be done in this thing 7.5 to 8 months if you really kick butt. Be nice to everybody and just don't test positive. Do you understand? Like I said, if you violate this thing, I'm going to issue a warrant for your arrest. You're looking at a year in jail. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this, you're stuck with this until you complete it or you get revoked. You understand? Shh. How do you plead to the offense? Guilty or not guilty? I will not find you guilty. I will withhold it for 15 months. Do well. Done. 7.5 months. All right. Good luck. Banner. What do you do? What do you do? Say it again.
He's working full time.
Okay. What do you do for a living?
Deliver fine.
Okay. How many kids you got?
So
Okay. Reduce the fees. Yeah. I'm trying to find out. So I'm gonna reduce the fees so you don't have to just pay a ton of money for supervision and stuff. My concern is more that you get the classes done, learn from this, so you don't end up with a felony, you know?
Yes, sir.
All right, good luck, Fred. Please. Thank you, Mr. D. Roll it. Wave it.
I guess.
Hi, good morning.
How are you doing today?
Good, it's Monday, right?
Well, hiya, it's Monday. I have Mr. Smoots, Derek Smoots.
Okay,
It looks like he picked up a felony case. And we wanted to get a reset, but we wanted to approach and see if you have any issues with the current bond that's on his.
Oy, oy, oy.
His bond is already set pretty high on his misdemeanor cases. We're just asking for another.
Yeah, is this, has he been in jail and they just filed this, or what happened? Did he get out? I mean,
He was already out on bond. Two of the cases was a violation of bond conditions. So I think when you picked up that felony,
Okay.
everything streamlined.
yeah, whatever you need.
Okay, thank
Just-
you.
Matt, you need me?
Yes, sir.
Talk to me.
Judge.
Mr. Blake Jenkins.
Took it on Friday. Went out over the weekend, so we need to verify this on. Why get you also?
Okay, do you mind bringing him up?
Jenkins.
If you pick up a fourth case, holy moly, I'm gonna absolutely lose it. Do you understand? I want my community safe. When you're out there, you need to make the right decisions before you do something. Think, if I do this, what's gonna happen? If I say this, what's gonna happen? And if it could lead to a bad result, then don't do it. Do you understand? Can you run his license to see, does he have a valid?
Eligible, Your Honor.
Okay, you're not allowed to drive unless you have liability insurance as well. Do you understand? If you don't have car insurance, you cannot drive as well at all until you have a license and car insurance. Do you understand? Okay. Do we have any conditions, on the terroristic threat?
Judge, I got assigned to him, he was already in the back.
Correct.
And so I don't know if there was anything with the previous case. I know one of them is against the brother. My understanding that I think.
So I guess tell me about it, Alex, please, on both terroristic threats. Who are they?
Terroristic threats? Yes, Judge. So on the first terroristic threat, the complainant and the defendants are brothers. Dispatched to a residence in regard to a family disturbance. The defendant was removing the complainant's belongings from the residence and putting them in the back of his own vehicle to prevent the complainant from getting his things. The complainant tried to remove his things from the vehicle and the defendant stated, "I will kill you." The complainant was in fear for his life when the defendant said this, and the defendant also later texted the complainant that if he touched his things again, he would cause him severe pain.
This is the second one.
And the second terroristic threat occurred on October 26, 2024, when the officer was dispatched to a Crunch Fitness. The officer made contact with the complainant, a manager at the gym, who stated the defendant was involved in verbal and physical altercations with other members of the gym, and multiple complaints were filed. The complainant stated the defendant's membership was canceled due to issues with other members and the defendant making threats. The defendant then continued to act aggressively after finding out this information and caused a disturbance by screaming and cursing loudly. The complainant told the defendant he needed to leave and not return. The defendant became more agitated, left the business, returned multiple times, and when the complainant stepped out with the defendant and told the defendant not to return, the defendant responded multiple times he was going to come back to the business and kill the complainant.
Okay, Judge, I would argue on that one. I'm gonna come back. I don't see an immediate threat or anything like that, any brandishing of anything or.
You're on, it's the going to that we.
Repeat what the threat was again?
He responded multiple times he was going to come back to the business and kill the complainant.
I'm gonna come back, I think that there's enough to go forward. Don't go back to these places. I don't want you to have contact with either of the complaining witnesses. Do you understand? I'm gonna have you sign these bond conditions, make better decisions when you're out there, Mr. Jenkins. At some point, someone is gonna stop bonding you out, and you will be stuck like Chuck in there until these things are over with, and it's gonna be a long time. Do you understand? You've asked me to give you a different lawyer. This isn't Burger King where you get your way. I will not give you another one. If you're unable to get along with Mr. Perez, then probably not him. Do you understand?
Yes, sir.
He may tell you things just because you don't like it. It doesn't give you a cause to complain and I don't like this person. No, he's going to give it to you. I've worked with him for many, many years. I trust him. He does a good job. That's why we gave him to you. You understand? Okay. So we'll have you sign these bond conditions and after that you'll be free to go. So he was not, I guess, having a good time with the prior lawyer.
Sure.
So,
I've spoken with his mom already over the weekend.
okay.
We had a really good talk about what was going on. I didn't know if she was gonna bond him out as soon as she did, so we're about to go have to talk to the factory about it.
My guess is though, is that if it's mom, she's not going to continue to do it because every time she bonds you out, all you're doing is you're giving free money to bonding companies. When you pick up new cases, all you're doing is you're giving money away. And I'm sure your mom doesn't have unlimited funds to just keep putting money away. Get a clue. What do you do for a living?
I worked for Uber because the job I was doing.
No, I just want to know, are you fully employed?
No, not at the moment.
You need to get a job. You have too much time on your hands and you become self-destructive.
It's hard to get a job because of my resume.
Did she tell you something? Do you think it gets easier in life? No. You don't even have convictions and it's hard for you to find a job. How hard do you think it's going to be if they end up in convictions? Do you see my point?
Sure.
Make better decisions. 95% people are in there because no self-control. All right, Matt.
And Your Honor, on both the terms of correct cases, there are previous conditions from.
Yeah, I will just have them sign those.
Okay, yeah.
So, so Matt, these are state's bond conditions, so they've already been filed, all he needs to do is sign them.
Does we have another arraignment? Page 4, Barnett, come on up.
The security sign on, we should get yours correct in November, but I'm gonna get the reckless travel ones during this time right now.
Okay. Is it, how do I pronounce your first name? See it? Nia? Okay. Ms. Barrett, you're charged with assault, bodily injury. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. The officer spoke with the complainant at Spring High School in Harris County, Texas, and the officer retrieved a video footage of the event. The video showed the defendant turn to the camera stating ready, and then began striking the complainant multiple times with a closed fist to her head and face as the complainant falls to the ground. The complainant stated she felt pain and showed multiple signs of redness on her face.
Okay, it's in the actual high school, huh?
Yes, Judge.
Okay. Ms. Barrett, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person. Do you understand?
That was, I
want you to listen because these are your bond conditions. If you violate these conditions, I'm going to put you in jail. I'm also ordering you not to be in possession of weapons as well. Do you understand? Do you have a lawyer today? Would you like me to appoint you a lawyer? Okay. Can you file those conditions, please, Alex? Okay. So what I need you to do, ma'am, is, are you 17, 18? You're 20? Are you actually in high school?
high school.
Are you, you don't go to this high school, right?
So I have.
Stop. I'm only asking you. Then you're not to go back to this high school. Do you understand? All right, so I need you to fill out an application for me. Deputy's gonna give you an application, and then I'll have you talk to a lawyer here momentarily. Do not leave until you sign our bond conditions, all right? Okay, please.
Sure. Page 11, top of 11.
Edwin Esquarca, come up.
Oh, sorry. Bob and
You have a lawyer today.
I'll have the next month.
You want to apply for court-appointed lawyer?
I was gonna get in this week, but last week my church messed up. So I'm fixing it right now.
You don't want me to give you a lawyer?
Well, I'd rather get it myself.
Your case is getting old. We can't just keep doing this. So, I mean, your case is 112 days old. I can give you a couple more weeks. Otherwise, I'm going to appoint your lawyer. We can't just keep doing this, you know? You want more time? You sure? Okay, how long do you want?
At least a month.
No.
2 or 3 weeks. So the next patient.
When's your next paycheck? Let's do that. If you don't have a lawyer by then, I'm appointing your lawyer. You understand? Okay, man, come on. Ready?
Yes.
Hi,
Snazzy, blazer you're on.
what's new with you, man?
What's up?
What's new?
Just same old stuff, you know.
I feel your pain.
Different faces, but it's the same. Yeah, you're right. Like I'm here on Kabir. Basically, he had T-Raz originally scheduled, I believe, on the 21st, but because of the weather and everything that got canceled. Just spoke with CLO. We were able to reschedule that for February 3rd. So you know, they told me I needed your permission.
Let's see, it's probably getting pretty old.
It is a little over.
Yeah, is everything turned in?
Yeah, all we're missing is the T-Raz assessment. I already.
Is he here now?
No, you're.
Supposed to be here.
Yes, and I told him, and he was here, I told him, and then he said, but it was rescheduled. I'm just being a messenger, so I know, I told him to come.
Council will reset.
Okay, so you have it set for next Monday.
Yes, Your Honor.
Let's do this. I'm gonna set it for bond forfeiture for next Monday. He has to be here. If I don't care what is going on, if he doesn't make it here next Monday, because I'm gonna have him come here and I'm gonna have to go do a walkthrough. If he's not here next Monday, I'm gonna revoke his bond. And don't.
And we scheduled T-Raz for 1 o'clock on Monday, so go right from here to.
Yeah, just have him come and we'll just send him, you know? Yeah, okay.
Appreciate you. Thank you.
Yeah, absolutely. Okay. Hey, what's up? Hey,
Morning, Your
hi,
Honor.
how are you?
I'm here on Miss Delaney Ibarra.
The last name.
Ibarra.
Ibarra, okay. What's the word?
So, I guess first for bond, she has no bond set in this case because she was on no bond for the felonies last time we were here. But the state is unopposed to a PR bond in this case because
She's being held at no bond on the upstairs.
I know, and the felony attorney is working on that. They resolved the felonies on Friday. And
They
the
resolved.
bond was not relitigated up there.
She's going into a PTI. She's going into like a like a 1-year PTI upstairs. And as part of that deal, we're gonna get rid of our misdemeanor, but obviously she needs to get out in order to get into the PTI and everything.
The felony attorney knows about the bond issue. I don't know when she plans to address it, but I'm just here to get her out on the misdemeanor.
Right. Since it's gonna be dismissed one way or the other with the felony PTI. So I just wanna make sure that, you know, our case isn't, you know, holding up the felony offer essentially.
Is she here now? Do we
Yeah,
have
she's
her?
in the holding cell.
Do you mind bringing her out? I mean, they don't even have a date set upstairs though.
You know, that's.
It's set for one
I know,
twenty-six.
I've spoken to the felony attorney, it was a misstep on her part for sure, but I spoke to the felony attorney and she will go approach on it at some point. I mean,
Are you anticipating a PR bond upstairs too?
I would assume so, yes, because she has a PTI, like the felonies have been resolved, so I would assume,
Never
yes.
assume anything,
I
you
know,
know?
I know, and I can't speak for what happens in the felonies, I'm only on the misdemeanor, Your Honor, but,
And I just see that the agreement's it's in deeds and everything, so.
Yeah.
It looks like we're moving towards that.
yeah.
I just want to make sure that we don't.
When do you want to set it for? Do maybe like a week
Yeah, that's fine.
and we'll see? Okay.
That's fine.
Does she have history of like flight? Do you know? Because she's got
She has
two.
no
prior-
history of flight. She lived in Houston most of her life. She is pregnant right now. She's 6 months pregnant. And essentially, you know, we just kind of want to
She
get
has
her
two
out.
prior assault cases. Both of those, any flight in respect to those cases?
I'm not, I actually ran over here.
I don't think, so. Based on what district clerk shows, no, Your Honor.
Let's take a look. I don't see.
All right, go ahead and sign.
So she only has one prior assault. It looks like that one was dismissed. And this new one here, looks like it was charged assault of a hospital personnel, right?
Yeah, that got dismissed on Friday.
Did they refile it as? Okay.
It just got plain dismissed. And then the PTI is for the assault on a public servant, I think. It's a mental health case, Your Honor.
I'm down with you. I'll grant you a PR bond.
Okay, thank you.
The only thing I'm gonna ask is that she stays in touch with you, right?
Yes.
I'm not gonna continue to do this. Like if she gets out, she just takes off, I'm not gonna do it again,
Yeah.
you know?
Yes.
And I'll admonish her
Yeah.
as such, so.
Thank you, Your Honor. I guess she'll still come out, right?
Yeah, I need to admonish her.
Yeah.
Who is our CW?
CW,
Hold on a second, we'll get there.
yeah.
Holland, tell me, what you got?
I have Sarah Castillo, Judge.
Okay.
That's the one where we were trying to get the records from the sheriff's office. They finally got them to me. And
You have everything you want?
I haven't been able to get through it all. It's like almost 600 pages.
Second, okay. I didn't- thought it was gonna be long. Okay, Gator. Blossom. Do you speak English, ma'am?
Yes, sir. Yes, Your Honor.
You see, Bar, I want you to understand and appreciate that you have a lot of lawyers that are going to bat for you now, trying to help you even get out. Your lawyer here is asking for a PR bond. You even have the state that's in agreement to get you a PR bond. The only thing that we're asking you to do is be safe to our community. Don't pick up any new cases and stay in contact with your lawyer. Right now, I'm going to grant you a PR bond, but I'm not going to do this over and over and over and over and over. I'm going to give you one chance to get out there and do the right thing, make the best of the chance that you're giving. But if you get out there and you just take off and you don't stay in contact with anyone and you pick up a new case, all bets off. Do you understand?
Yes, Your Honor.
I'm not asking for much. All I want is my community to be safe and for you to stay in contact with counsel. That's it. Okay, so I'll grant you the PR bond. Looks like the bond is already set. We're gonna set it out for a week because you're still at no bond upstairs, so we don't know what's gonna happen in your felony case. So we'll set it off for a week and then we'll go from there, okay?
Yes, Your Honor.
Do you have any questions?
Yes, Your Honor.
So tell me about this one here. Who's the complaining witness?
Dating relationship, boyfriend.
Okay. Does he want to have contact with her?
He's not, we haven't really been, he hasn't been cooperative with, so I wouldn't be able to tell you what he wants other than to drop charges, really.
So I want you to understand that I am going to grant what's called a magistrate's order for emergency protection that identifies Mr. Rodriguez as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072, which is the stalking statute. You cannot threaten, harass, use another person to communicate threat or harassing behavior, and you cannot be in possession of a weapon. Do you understand?
Yes, Your Honor.
I'll take off the residential restriction just in case, but everything in the MOAP is stuff she shouldn't do anyways. All right, understand.
Yes, Your Honor. Thanks.
Judge, I just had a quick question. We're set for trial tomorrow in ERD on a family violence case. And I just wanted to know logistics wise, would we pick tomorrow and then start Wednesday? Or if we have a jury tomorrow, do
Are
we
you
just?
really gonna go?
I mean, it sounds like we're gonna go.
You hear this?
Yes, Your Honor.
I've got 7 other cases set for trial as well tomorrow in here.
Okay.
So let's see which one actually
Yeah, let's see
goes.
what the trial
So,
occurs.
but technically, we pick on a Tuesday, everything starts testimony on a Wednesday, and then we go. That's the way. So, yes, thank you. Hi, Colin. You ready?
So, we're on the docket for tomorrow. I stopped by today.
Okay,
Push it out a little way so I can have some time to go through that and then.
okay. So are you happy?
As of right now, I am, Judge. I just need to go through it and
So you actually got everything, huh?
they've given me almost 600 pages worth of documents, so that's.
Wow. Careful what you wish for, is that, right?
Sometimes.
How long do you want?
Can I have like a month?
Okay, but at that time, it's clear trial. So, because it's beyond old. And I'm glad that you got everything you got, but it's time to, so we'll give you the 30 days, but that's, yeah, okay. Have fun. Just let her know and then we'll go. Okay. Hi.
Judge, I have 3 appointments, 2 out on bond, 1 in custody.
Okay, who do you want to talk about?
Bond, I just wanted to see if I could revisit, not really visit, just kind of modify the bond conditions slightly.
Absolutely. Who are you talking about?
The first one is Mr. Perez, Judge. Jose Perez.
This is a DWI.
Yes, sir.
Okay,
I understand that he lives in Dallas, Judge, and he was wondering if he could do the UA somewhere over there.
so what'll happen is, Perez, come up. Oh, Blasi, you're still here. Wonderful. Yay. I don't care where you live. I don't care what you do. You are still under bond condition of this court. If you do not have a Texas driver license and if you do not have liability insurance, you are not allowed to drive. Do you understand?
I haven't driven.
I am also ordering you not to consume alcohol or illegal drugs. If you get called upon to take a test, you must go to a Quest Diagnostics in Dallas, take a test there, and get the result to your lawyer. It is on you to do that. Typically, when we have someone that does it here, they come into here to downtown and they take a test and I pay for it. But because you're over there, I cannot pay for it. You will be required to foot the bill on that. If you fail to go test when you're called upon, I will issue a warrant for your arrest. There are no more PR bonds. You pick up a new case, you violate any of these conditions. Do you understand? One more thing. I don't know what your immigration status is, but if you go to jail and you're not in this country with permission and you spend any more than 46 hours in custody, you will probably get an immigration detainer and it's not going to go well. So if you're not in this country with permission, you better live like you have a halo over your head. You understand? All right. Good luck. Thanks.
And the next one, Your Honor, is sort of.
Just take a seat.
He's also just asking that if he can change the location of his UAs. And I wonder if I could just speak to
Where does he
about
live?
that. In Pasadena, Judge, it seems like
No.
somewhere in South Houston. He said, okay.
Still under bond condition of this court, still required. If some time passes and then he's good, then we can perhaps modify. But this is the beginning of the case. I want to make sure that he's not using it.
Yes.
I don't know him. I've never met him. And so, right, I'm just doing everything that I would do to every single other person. Yeah.
Excellent. Thank you, Judge.
Absolutely.
The last one, Your Honor, is Mr. Francisco Cerda. He's in custody, Judge, and I wonder if it's on bond.
Is that C or an S?
The C, Judge, the RDA. Oh, he's right here.
Good morning, Mr. Cerda. You are charged with engaging in organized criminal activity. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 21st, 2025, the officer was dispatched to a residence in Harris County, Texas. In the call notes from dispatch state, the reportee says an unknown party stole her neighbor's U-Haul trailer. Subjects were seen headed towards Pasadena Boulevard. The driver was a skinny, tall male, and the reportee lives on Buchanan Street and has camera footage of it happening. A witness stated he observed individuals taking the neighbor's U-Haul. The officers located the U-Haul and a felony stop was conducted. Defendant Hentoja was observed unloading items from the U-Haul, ran to the back of the residence, and prevented officers from arresting him. Defendants Lopez and Cerda remained in the U-Haul, and the complainant stated the value of the trailer was $1,800 and dirt on the trailer was $300.
I have so many questions.
Yes, Judge.
I don't even know where to start.
That's my concern. If you may, I want to bring some, I guess, points of arguments to the court's attention. The first one, my concern is that, I mean, the 911 caller mentioned unknown parties, and then the police officer later mentions them as suspects without any type of articulable facts, believe that they are the specific people or the individuals that have taken this U-Haul. Now, as we know, probable cause requires more than a hunch, more than suspicion. It requires something else, more than that. And that seems that that's all that the things, at least under the four corners of the things, allege that my client was involved with this alleged theft.
I mean, remember, like, so when they start an investigation, sometimes they just don't have everything and facts develop in time.
Right.
Here, we have a call that several people have stolen a U-Haul.
Yes, Judge.
And they've given a description of a tall, lanky person, right?
Yes, Judge. And respectfully, we defer to the court because all it says in the DIMS is that the defendant Cerda remained in the U-Haul. There's no further information regarding Cerda.
Where was he in the U-Haul? Was he in the actual U-Haul? Was he in the truck that was driving the U-Haul? How was he engaged in this alleged criminality? Like,
and Your Honor,
can you does mere presence impute criminality?
Judge, and that's exactly right. Texas law says that mere presence is not enough.
Dude, I'm with you.
Oh, yes, sir.
But so
we're not arguing against that, Your Honor. And like I said, we defer to the court because we don't have that information. We'd have to await the OR, and we don't have at this time.
But I'm not going to sit here and hold
Judge.
someone.
And that's why we defer to the court.
Let's look at what the statute says, because, 7102. A person commits an offense if with intent to establish, maintain, or participate in any combination or in the profits of a combination or as a member of a criminal street gang, the person commits or conspires to commit one or more of the following. One is murder, capital murder, arson, yada, yada, yada. Two, any gambling offense punishable by a Class A misdemeanor. Promotion of prostitution. Number four, unlawful manufacture, transportation, firearms. Which one are you relying on?
Your Honor, as it's pled that it's pled as theft as being the underlying basis of the engaging in criminal activity. And right now, Kelsey is looking at the case. We may very well dismiss this because of the insufficient evidence in the information in the DIMS, but right now, Chief is looking at it.
And Your Honor, if we could just maybe reset it for a week or so and call the witness.
He's in custody, and I can't, I mean, if he was on bond, that would be one thing, but he's in custody. I'm not going to hold him just because, and the compounding it, Casey, is that he's got an ICE hold, so I can't give him a PR bond,
I just need a little more time, Your Honor, to discuss it right now.
Yeah, I'll find no PC because I just don't think it's there for now. And then if you find something later on, by all means, but all right, Mr. Sird, I'm going to find that there's no probable cause to go forward in your case. Just, Mr. Serta, be careful who you hang out with, Okay, all right, for sure.
Counsel.
Mr. Ewing. Hey, good morning.
I'm approaching on a case off docket set for Wednesday.
Okay.
Oh, do you need the cause number? 2538599?
On Johnson?
Yes.
Okay.
And the state had offered a clean and green. It's a POM case. No. They had offered clean and green. It's a PTI program.
On our case.
Right, on our case. And he signed up back December 13th, and the earliest date they gave him was February 28th.
Okay.
And so I was just, he's set for Wednesday. I was just gonna ask if we could reset it to like early March.
Okay, but if he doesn't show up and if he doesn't do it, then
Right, if it's not done by then,
it's
then I
old.
understand.
It's old. It's either, like if he, first, I'm gonna set it for SFBF for the day that you want it. If he shows up and it's done, great, they'll dismiss, right? But if he doesn't do it, if he doesn't show up, then it's plea or trial.
Go to trial or whatever.
Yeah, okay. Whatever day he wants, you know, just set it for maybe like a week and a half after that day of whatever the cleaning green is. And then,
Not early March and then.
yeah.
Thank you.
Wait. What day is the cleaning green?
The cleaning green is February 28th.
Okay, yeah, then early
Yeah,
March.
we signed up
Absolutely.
back at this.
Yeah. You're
Less
good.
than a month old.
Don't worry about it. You can. Hi, Aaron. How are you, man?
Doing well yourself.
Good. You know, Monday. Guys, ready?
They're bringing my client up for a plea. I'm ready.
Talk to me.
Montanez, Yanel Montanez. You had wanted him to get a drug screen this morning. He went over there. He thought that it's negative.
Right.
Just
Just
check.
do a normal reset.
Yeah, just wait on body cameras and see where we go from there.
Have fun. Good morning, Mr. Ortega. So you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 81 days in jail, credit for the 81 days that you've done. You need to understand that this will reflect now as a conviction on your record. It's going to be there for the rest of your life. From now on, any new misdemeanors that you pick up, you will be facing a minimum of 30 days in jail. You understand?
Yes, sir.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to test on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Is this what you want to do?
Yes, sir.
How do you plead to the offense, sir? Guilty or not guilty? How do you plead to the offense? Guilty or not guilty?
Oh, I already know.
I'll find you guilty. I see that you got a probation upstairs. Let me say that you're very lucky that you got one with the type of cases that you have. Felony probation is no joke, so don't take it as a joke. You're young, you're still held to a high standard, and you're expected to complete everything you don't. If you go on, you use drugs, you pick up a new case, you could be very well spending a lot of time in prison. You've been given a chance. Make the most of it. You understand? All right. You ever need any help? All you got to do is come back here. Anything you need, cell phones, tablets, food, jobs, we can give you anything that you need. All you got to do is come back and ask. All right?
Yes, sir.
All right, man. Good luck.
Thank you, Judge.
Thanks.
So that.
Mr. D.
Yes, sir, we have a plea on Mr. Marvin Lockridge. Mr. Lockridge, step forward, please. Yes, sir, in your surgery, Judge, okay? Yes, sir.
Mr. Lockridge, charged with possession of marijuana, you're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 6 days in jail with credit for the 2 days that you've done. Is this what you want to do, sir? They've offered
That's what you
you,
want to do. 6 days credit for 2 times, sir. Yes, sir. Yes, sir.
understand that this is going to go on your record. It's going to be there for the rest of your life. You need to understand that from now on, you're facing at least a minimum of 30 days in jail for any new cases that you pick up. You understand? You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. How do you plead to the offense, sir? Guilty or not guilty? I'll find you guilty. I'm going to sentence you to the agreement. I'll roll your court costs so you won't owe anything. Good luck to you, sir.
Thank you, Your Honor.
Thank you, Mr. D.
Pass me the book, sir. Yes, we have another CHA,
Okay.
page 23. Malvo, Deja, come on up.
Good morning, Ms. Melba.
Good morning.
Do you have a lawyer today?
No, I need to get a court appointed attorney.
I'll appoint your lawyer today, Ms. Malvo. Your case is extremely old and it's time to figure out what we're going to do with your case. So I'll have you talk to a lawyer. Is there an offer on this case now?
Yes, Judge. There is a deferred offer and a 30 days jail offer.
All right. So do you mind reaching out to the MAC?
Yes, Judge.
If you mind just taking a seat for me in the jury box, we'll have you talk to someone here momentarily. Mr. D.
Yes, sir, Your Honor. Your Honor, I am here on Miss Sherry Johnson. It's my understanding that she has been given bond conditions to be signed by you. However, the bond conditions state there is to be no contact with the complaining witness. Your Honor, if I may, the complaining witness and the defendant have a child together. I would respectfully request that that be changed from no contact to no threatening or harassing contact between the two parties because they have a child.
I get it. However, from my taking of reading it is, correct me if I'm wrong, it's the report in there lies that is she trying to get charges filed against him?
Yes, she's trying to get charges filed against her husband.
Does he want to have contact with her?
We haven't had a chance to reach out.
Not until I know what he wants, you know?
I think he's
I'm not
here,
gonna-
Judge.
Is he?
It looks like
he's here.
Say, can you let them know?
If he's here, we can reach out. We can talk to
They
him.
let you talk to him.
Is he here?
Yes, he's here.
No, but I'm gonna have the state go talk to him if you don't mind.
I'll talk to him.
The complaining witness in the Sherry Johnson case is right there. I don't, you know.
Morning, Your Honor.
Of course. We have here.
Leonardo Gomez.
Down before reset.
Good morning, Mr. Gomez. Shh. Mr. Gomez, you are charged with driving while intoxicated. First offense. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. I'm sorry, state, I forgot to grab you. My fault, I forgot to grab you.
Quiet with the interpreter, please.
You have been offered 15 days in jail with credit for the 5 days that you've done. You need to understand that this will reflect as a conviction on your record today and forever. From now on, any new cases that you pick up here, you will be facing a minimum of 90 days in jail. Are we going forward with the enhancement on the 15 or not?
It's gonna be a bad.
Are you sure?
Oh, I'm sorry. No. Yes, it's not true.
Right. Is it true or untrue that you had a 0.15 or above, Mr. Gomez?
It's true.
Is it true to the enhancement? So understand, that's what makes it a Class A misdemeanor. So from now on, because this is going on your record, if you ever get charged with a future one, you'll be looking at a minimum of 90 days in jail. You'll give up a lot of rights by entering into this agreement and this plea bargain agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, you can never change this or undo this. Is this what you want to do?
Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I'll find you guilty, sentence you to the agreement. I am going to suspend your driver license or the ability to drive for 90 days. Do not drive until you get a license, and good luck to you, sir.
Maybe she's.
You spend. Hi.
Hey, good morning, Judge. I got 2 new cases this morning. The first one,
Wonderful.
Barrett.
Okay.
She's in the box. I didn't know if you needed the conditions on her. It's an older case.
It is. And so what I was going to do is give you guys a setting, okay? Like a normal 30-day setting, but at that time, she's got to come back here. She needs to make addition on what she's got to do.
Okay.
Case is 250 days old, so I'll give her one setting. Come up. Ms. Barrett, come up. No. I'm thinking of someone. This case isn't that
It
old.
was a 2B. It's like 4 years old, 2B.
Okay. I was thinking of another case. Okay, Ms. Barrett, so we'll just give you normal, just setting. I've given you a lawyer, ma'am. I'm not asking much. All I'm asking you to do is don't pick up any new cases and stay in contact with your lawyer. If you take off on us and we don't get to hear you or he tells me that you've gone AWOL, I'm going to issue a warrant for your arrest. You understand? Okay? Good, that's it. All right, ma'am, just take a seat for me.
And then Christine, PRE.
This one is 200 days old, so we'll give you a setting, try to figure out where things are going, and then she's got to be at the next time. Is there an offer on this case? On Prejean? That's the last name. Please.
We'll leave that clear criminal history. Walmart.
So she can't go to Walmart as part of her bond conditions, so, but that's it.
Not the same thing.
I believe there is, but let me double check real quick.
I'll talk to GDR.
Okay, we got you. Okay.
Hey, Judge.
Hey, I just emailed. I just emailed. Let me see. Who do we order a panel on?
I don't know who officially it is. Apparently DVD said that they have a case too. That was just brought to my attention, but don't use the oldest first.
Typically. What about Butler's case? Is he ready?
Is that Garcia? Or preferably Garcia. I don't think we have any custody.
Yeah, it's Garcia.
Yeah, that one's good.
Okay.
And then the DVD one, I just got informed that they have one as well, but it's in the RD.
Well, these cave so much, so I don't want to rely on that one over there when I know 100% that he's ready, right?
I can't say 100%, but I'm pretty sure.
Do we know, Ramona, that Mr. Butler is 100% ready? I thought he was, right?
I thought that's what he announced it on Friday.
So let's order the panel on that one then. And yeah, so. Hi. Yes, ma'am.
I have this warrant set for the bond resolution hearing. I talked to Mona, she's getting set up, and I think the state's getting set up, so whenever we're.
I have to leave. I gotta go get my kid at school. There's a problem, so.
Okay.
Can we do it tomorrow?
I can. Yeah. I didn't know about this torrent, because it's 3 days.
Well, I didn't know, but
I
so
didn't know,
pick a day later this week then. I don't care.
Friday.
Sure.
Okay.
Mr. D.
Yes, sir.
Talk to me.
I believe the state has some information, Judge.
Yeah, so we're unopposed to changing the condition to no threatening or harassing. We're fine with that completely due to them having a child together, so.
Okay. So if you can follow appropriate paperwork, please. Yeah,
Thank you.
sure.
I understand.
For the jury charge, you want 30 or 32?
35.
35?
Yeah.
9 or 11 PM, I mean AM.
AM, 9 AM.
Got it.
Yeah.
Thank you.
Yeah. Abel, I gotta run. Do you need me for anything?
No, sir.
Judge, did you get an answer from Mr. Butler?
His office seems to say that they're ready to go forward.
Okay, that's what I
I mean, I
thought.
called and I mean, I guess if you want to send an email just to make sure, but their oldest,
Okay, Judge.
yeah. Okay. Hey, Pip.
Yes, sir.
I gotta roll. I have something somewhere, but we'll finish and send that. Okay.